Hi, everyone. It's Rob Ryder on Sunday, December 22nd, 2019. Merry Christmas. A little early, but it's right around the corner. And today we're going to talk about arbitration rules the nation. And it really looks like it does. It certainly rules title insurance, real estate transactions, although they say mediation mainly, but it's still ADR, alternative dispute resolution. And it looks like federal agencies also use alternative dispute resolution. And so, like for myself as a veteran, it's like, well, okay, I'm going to try the ADR route with them to get the entitlements that are being withheld. All right, not taking them to court, I'm going to take them to arbitration. And I'll show you why that's really a good thing for a layman is to have it in arbitration where it's non-judicial. Then having it as a judicial hearing. Now, the court may supervise the arbitration, but it isn't the court doing the arbitration. It's all private, right? So, and that would be biblical. You have every word established by 2 or 3 witnesses. There you go. That's what we're going to do. Before you go to court, have every word established. So, a lot of this apparently comes out of the United States Code, Title IX on arbitration, which is positive law. So that would mean in the state courts they have to recognize it also. And it's, we'll look at that in just a second. Not very long, but it's pretty powerful. And arbitration is right in your title insurance policy. And so whether you're in a foreclosure or not, as you're going to see when we start looking at some documents and you go find yours, your name, full legal name, is not on the frickin' title insurance. Well, then you're not being insured. And you need to complain about it and use arbitration if necessary to get your name put on your damn title insurance. Because you're not protected. It's part of the scheme. I'll show you. So that's where we're headed. But before we get there, hey, can you pay it forward? Or if you need to, call it charity. And PayPal account is for Rob Ryder at AOL.com. If you don't have a PayPal account and want to use a credit or debit card, well, you can send me an email for an invoice that I will send to you via PayPal in the amount of your donation. So in other words, you need to tell me what you want to donate. I'll put it in an invoice, send it through PayPal to you. You can pay for it on a credit card. Or you can always use the mail. Robert Allen Retluski, 10955 14 Mile Road Northeast, Rockford, Michigan, 49341. Hopefully I won't have to do this much longer, because if this arbitration is the path, arbitration is done very quickly. And we've already, on Friday, applied for arbitration in a foreclosure case in Florida. Look at that in just a second and, see what happens. But it isn't hard to do. If you're in a court case right now, you just say, you put in a motion asking the court to send the civil action to arbitration. So give me just a minute to load up a few documents, and I'll show you exactly what I'm talking about. Hang on now. Okay, so, hey, we got to look at just a little bit of law first, and then we'll go look at documents, which are much more telling. But, this is the law, Title IX arbitration in the United States Code. And it is positive law, and because it's positive law, the state courts have to follow it, right? So if you invoke Title IX, it's good anywhere. And it says in here that, let's look at the definitions, right? Maritime transactions and commerce defined. Exceptions to operations of title. Maritime transactions as herein defined means charter parties, bills of lading of water carriers, agreements relating to wharfage, supplies, furnished vessels, or repairs to vessels, collisions, or any other matters in foreign commerce. Or any other matters in foreign commerce. So anything in foreign commerce, right, is called a maritime transaction. Which is subject to controversy, shall be embraced within admiralty jurisdiction. Right? So Maritime transactions are international, and it looks like commerce is national, because commerce, as herein defined, means commerce between the several states with foreign nations or in any other territory of the United States or in the District of Columbia or between any such territory or another or between any other territory in any state or foreign nation or between the District of Columbia and any state or territory or foreign nation. Yada, yada, yada. So, you got either maritime transaction or commerce. And so if it has to do with commerce, in this case, validity, revocability, and enforcement of agreement to arbitrate, a written provision in any maritime transaction or a contract evidencing a transaction involving commerce to settle by arbitration a controversy thereafter arising out of such contract or transaction, or the refusal to perform the whole or part thereof. It must be talking about the contract, right, or the transaction. Or any agreement in writing to submit to arbitration an existing controversy arising out of such contract, transaction, or refusal shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. So if it says you're going to arbitrate, well, then the court's going to make you arbitrate. Right? Stay of proceedings were issued therein referable to arbitration, if any suit or proceeding be brought in any of the courts of the United States. And so that should be any court in the United States that has a United States flag in it, which they all do, right? So that's a court of the United States. Any court you go to, see a gold fringe flag, court of the United States. Upon any issue referable to arbitration under an agreement in writing for such arbitration, the court in which such suit is pending, upon being satisfied that the issue involved in such suit or proceeding is referable to arbitration. Well, how would they know that? Show them the contract. Under such an agreement shall, on application of one of the parties, stay the trial of the action until such arbitration has been had in accordance with terms of the agreement, providing that the applicant for the stay is not in default in proceeding with such arbitration. Right? So you would be the one that want to ask for arbitration, and that's going to stop the civil action, which is the judicial side, so the arbitration can go on to settle the matter between the parties privately. I think it's pretty interesting. Good deal. So, hey, as I'll show you, in a title insurance policy, it says right in there arbitration. And the policy doesn't have your name on it, so it's time to arbitrate. First asking to change it, and then, if necessary, taking to arbitration. But beyond that, in the federal government, the Administrative Dispute Resolution Act of 1996 was passed in, 1996, in which it says that this act may be cited as the Administrative Dispute Resolution Act 1996. The Congress finds that administrative procedure, as embodied in Chapter 5 of Title 5 United States Code and other statutes, is intended to offer prompt, expert, and inexpensive means of resolving disputes as an alternative to litigation in the federal courts. Administrative proceedings have become increasingly formal, costly, lengthy, resulting in unnecessary expenditures, yada, yada, yada. So, they came up with their own ADR program. That's what this is. But, Public Law 104-320. You might want to write it down and go find your own copy. So this is to be used by, the different agencies. And sure enough, on the VA, they have an alternative dispute resolution section that has to do with this exact thing, right? So I haven't really had a chance to study this out too much, but it's like, okay, well, it looks like there's another avenue with the VA or with any other agency that you're having an issue with, if you can get them into ADR. But that'll be for another time, because it's a little bit easier to show for right now what's happening in somebody's title insurance case. So if you bought a house, you got title insurance somewhere, right? You just need to find a copy of it. And who's ever servicing your loan, whoever you're getting your bills from, ask them. How do you get a copy of your owner's policy of your title insurance? Right? American Land Title Association Owner's Policy 101792 with Florida modifications. And it's got a policy number. Subject to the exclusion for coverage, exemptions of coverage contained in Schedule B and the conditions and stipulations of Old Republic National Title Insurance Company, a Minnesota corporation, herein called the company, insures as a date of policy as shown in Schedule A against loss or damage not exceeding the amount of insurance stated in Schedule A, sustained or incurred by the insured, right? By the insured for reason of. Well, who did they insure? If they didn't insure you in your full legal name, then they didn't insure you. They insured a thing. Or they insured someone else. Right? So, and as it turns out, there's supposed to be an owner's policy and a lender's policy. So if you don't make your payments, it should be paid for by jeepers, hang on just a second. The foreclosure should be paid for by title insurance. So why are they taking you to court? Right? And so there's something fishy going on. And we're going to study it out here in just a second. But it never fails. The phone rings. Hang on. Okay. Now where was I? So here's the owner's policy. And it's got a Schedule A and a Schedule B. And hey, it's got a seal, been signed, right? Attested. It's a contract. They say this is a contract between you and them. The problem is you aren't on the frickin' warranty deed. Well, you're not on the title insurance or the warranty deed. Because on the Schedule A, right, this is who's insured. The insured who hereunder in whom title to the fee simple estate is vested at the date of hereof is, right? And they spelt Jacqueline different than is spelt on the warranty deed. But in either case, this shouldn't be a thing. This should be a person. This should be you, a natural person. In fact, on another guy's insurance policy, it says on there it has to be a natural person. So there's the reason to go to them to say, hey, we need to change this policy. My name isn't on it. And here's Schedule B. These are the things that are supposed to not be covered. And, we'll worry about that later because right now we're only worried about the fact that our name isn't on the damn policy. And it goes on and on and on. But in 14, it says arbitration. Unless prohibited by applicable law, arbitration pursuant to the title insurance arbitration rules, American arbitration, may be demanded if agreed by both the company and the insured. So if we can't get them to change this by just nicely asking and put your name there, then you can take them to court under Title IX, because this is a contract in commerce, and make them go to arbitration and make them change it. Because in arbitration, again, you get to subpoena people and have them put under oath, which that stuff doesn't happen in a courtroom. I'm afraid they don't do that. So this is what we put into, this is what we put into Jackie's case, which is about this well, this is her title insurance. But it isn't because of the title insurance we had put this in. We had put this in because of what it says in Florida under their, page 11, okay. This is the 2018 ADR Resource Handbook, Florida Dispute Resolution Center. You can download this online. And on, we'll just go through it. There isn't that many pages. Blah, blah, blah. What they do, how they do it, how they define things. What's circuit court mediation? Means mediation of civil cases other than family matters in circuit court. That's simple enough. What's county court mediation? Means mediation of civil cases within the jurisdiction of county courts. So this one, they have to be within the jurisdiction of the court for them to mediate. And this one, they just has to be in the circuit court to mediate, because the circuit court's the state court and the county court is like a municipal court. Dependency, court-ordered mediation. Court-ordered mediation shall be conducted according to the rules and practice and procedures adopted by the Supreme Court. A court, under rules adopted by the Supreme Court, must, upon request of one party, refer mediation of any filed civil action for monetary damages, providing the requesting party is willing and able to pay for the mediation, the cost equitable divided between the parties, unless these reasons. And one is the action is filed for the purpose of collecting a debt. Now, all the paperwork that they put in says on it was gathered for collecting a debt, but I don't know that that's why the action was filed. They say the action was filed for a foreclosure, even though all the paperwork says it's to collect a debt. So, apparently they misfiled. And we need to say, well, it says collecting the debt, because I don't think you want mediation, right? That's just voluntary, and it's nobody's under oath, and so forth and so on. But these are reasons you can't mediate anyway. So one is parties have agreed to binding arbitration. Okay. Or it's medical malpractice. I think we can put in claims of medical malpractice against the VA for anybody who's gone in and came out worse. Well, this would be with any doctor. If you come out worse from the doctor than you went in, that was malpractice, because he's supposed to do no harm. But I think the claims need to be made by arbitration, not lawsuits. And that's where they're, it's just a diversion. May refer to mediation, any part of file suit. Mediation is not required under this section. Okay, well, that's all good. We go a little bit further and we get to court-ordered non-binding arbitration. So court-ordered non-binding arbitration shall be conducted according to the rules of practice and procedures adopted by the Supreme Court. Okay, so now you're doing it under the guidance of the Supreme Court, not some local court. A court, pursuant to rules adopted by the Supreme Court, may refer any contested civil action filed in a circuit or county court to non-binding arbitration. Well, that's exactly what we're going to do, or did. So, in her case, then, Jacqueline Victoria Vesey, real party in interest, application, court-ordered arbitration. Notice, I, Jacqueline Victoria Vesey, the real party in interest in the contested property in this civil action, make application to the circuit court for court-ordered arbitration in accordance with Florida court-related alternative dispute resolution statutes. That's the stuff we were just looking at. The United States Code Title 9, which we already looked at, and the common law, because it's common law to arbitrate. That's going to your brother first and, take it before the witnesses, before you get to the court. So the reason I use it this time is, and this will be true on anybody's loan application, no matter what style it is. Everybody has some kind of uniform residential loan application. Fannie Mae, Freddie Mac, or in this case, the Rural Development Assistance Form 410-4, Uniform Residential Loan Application, used as part of the process in obtaining a loan through the United States Department of Agriculture. Right, so that's what that form is for. If you wanted to get a loan through the United States Department of Agriculture, they'd have you fill out a Form RD 410-4, Uniform Residential Loan Application. If you didn't get it through USDA, then it will be like a Fannie Mae Uniform Residential Loan Application. But whatever it is, you're going to have a Uniform Residential Loan Application as part of your process in getting a mortgage, right? So they should send it to you if you contact the servicer and say you want all the papers they have having to do with your transaction. And, you know, I would think that would capture this uniform residential loan application and your title insurance policy. But you may want to ask for that specifically and say, and I want to be sure you give me the title insurance policy. You want the owners and the lenders, because I believe that the buyer pays for the lender's title insurance policy, so you paid for it. You should be able to get to see it. Anyways, back to this thing, right? So the Rural Development Assistance Form RD 410-4 Uniform Residential Loan Application, used as part of the process of obtaining a loan through the United States Department of Agriculture, was never signed. They never signed their paperwork. Was never signed by the loan approval official. And they do that on page 8 of 10 of this Form RD 410-4. So if you Google Form RD 410-4, you'll find it. Go to page 8, and you'll see a place on there for the loan approval official to sign it. It wasn't signed. And I never received a loan from the lender identified by the mortgage, which is another form they had, submitted as Composite Exhibit A of plaintiff's alleged verified complaint, because they always put a copy of your mortgage or deed of trust or whatever the thing is they're saying obligates you to make this payment, right? The problem with that document then is, well, I didn't get the loan, so that didn't happen. Yeah, I was going to do it. I was ready to do it, but you never signed the papers, so we don't have an agreement. Right? The lender refused to execute RD 410-4. So now we contest the action and we're asking for arbitration. Therefore, I petition the court for good cause shown to authorize the arbitrator to issue subpoenas for the attendance of witnesses and the production of books, records, documents, and other evidences at arbitration, and may petition the court for orders compelling such attendance and production at the arbitration. Subpoenas shall be served and shall be enforced in the manner provided by law. Basically, I took that sentence right out of their writing and put it into our complaint. And so Jackie filed this on Friday. It hasn't shown up in her docket yet, but, she does have a docket. If you go to Lake County Clerk, Florida, and then hit search, you can put in this case number, 35-2019 CA 001306. You got to hit the search button, and they got a place where it says put in the case number. That would be the case number. And now there's 86 entries. So when there's 87, that should be her application. Hopefully they put it in on Monday. And we'll see if we can get them to go to arbitration on this deal. So that was kind of a sideways to get into it. This was based on what the rules said in Florida, right? This is right out of the ADR, Alternative Dispute Resolution book, that says the court, pursuant to rules adopted by the Supreme Court, may refer any contested civil action filed in a circuit or county court to non-binding arbitration. So ask them for it. An arbitrator, in the case of a panel, a chief arbitrator, shall have such power to administer oaths or affirmations and to conduct the proceedings as rules of court shall provide. So you're basically doing court administratively, right? It's non-judicial. If you're in the military, this is Article 15 compared to court-martial, right? We're going to do it administratively. The hearing shall be conducted informally. Presentation of testimony and evidence shall be kept to a minimum, and matters shall be presented to the arbitrators primarily through statements and arguments of counsel. Any party to an arbitration may petition the court in underlying action for good cause shown to authorize the arbitrator to issue subpoenas. And since this stuff is being done under the Supreme Court, it's like, getting a subpoena from the Supreme Court. The arbitration decision shall be presented to the parties in writing. An arbitration decision shall be final. If a request for a trial de novo is not filed within the time provided by rules proclamated by the Supreme Court. So, you know, it's non-binding for 30 days. If you want a trial, then go ahead. You can have a trial, but, it's non-binding. But after 30 days, well, it'll be final. A motion made by either party within 30 days of entry of judgment. The court may assess costs, use the party requesting trial de novo. Da-da-da. So I'll worry about that later. But I'm trying to get them just to put it into arbitration to start with and issue some subpoenas and get people to come in and swear under oath what the hell's going on. So, as things work, I'm going through all this stuff, and then I had found, or actually Jackie had sent it to me because we were looking for any documents that talked about having arbitration because of Title IX, and it's your title insurance that talks about arbitration. And this title insurance, let's see, where's the start with number 1? 6. I think this one's upside down. Is that what it is? Yes. So now this is going back again, right? Go find your title insurance policy. You'll see that it doesn't have your name on it. Rotate. But what is your title insurance supposed to do for you? So I could read all these, but I don't want to take that much time. I might do that. I might do a whole video on this separately, but I'm just laying out some, basics right here, and then I'll see what happens next week. Notice of claim to be given by insured claimant. So this is what we're going to do now. We're going to file a claim with the title insurance company under their notice of claim, right? To say, hey, the wrong name is the insured. We need you to fix it. So the insured shall notify company properly in writing in case of any litigation as set forth in Section 4A below. And this is the other reason. Because they're supposed to come to your defense if you're being sued or there's any legal action against your property, the title insurance is supposed to provide your defense. And in Jackie's case, she's in foreclosure. They're not there. So apparently there's a problem. So go file a claim and say, that you're in court. Here's the court case, and because there's errors, administrative errors in who the insured is on your title insurance, you're being denied the services that you paid for. And if they won't fix them, you're going to have to arbitrate it. Right? Cover all the bases. Boom, 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 boom. And send it to them. So, okay. In a case, knowledge shall come to insured hereunder of any claim of title or interest which is adverse to the title of the estate or interest as insured, which is fee simple, right? It's been insured fee simple. You shouldn't even be paying property taxes. And, so here's the thing. The property taxes don't come in your name either. So if you put on this title insurance policy your name and say you're the insured and you get a tax bill that comes to you not in your name, and they don't use the same legal description as is used on the warranty deed, right? So you're being charged a tax on something you don't own. Well, then these people are supposed to defend your title. Defense and prosecution of actions. Upon written request by the insured and subject to the options contained in Section 6 of the conditions and stipulations of the company, at its own cost and without unreasonable delay, shall provide for the defense of an insured in the litigation in which any third party asserts a claim adverse to the title or interest as insured, but only as to those stated causes of action alleging a defect, lien, or encumbrance or other matter insured against by the policy. Well, that's what they're doing. I say so. If the title insurance company disagrees, then we'll arbitrate and get their agreement and prosecute the case. Right? That's the idea. So, okay, well, that's the general idea on that one. I want to show you another one that, same information with different words. It's always good to see it differently. So hang on. Okay, one more thing before we move on. See how they spell Jacqueline's name here? Jaquequueline. VC, comma, a single person. Well, that ain't quite how they did it here on the warranty deed. JACQ. And the other one had an E there, right? So they're not spelt the same. They're not the same person. And, so she isn't, this is a thing also, right? Jacqueline V. Veazey, a single person, is a thing. That doesn't have an address, right? Jacqueline, in her full legal name, has an address. So they're doing this on purposely wrong. They're replacing your person with the thing. And they, not even the same thing between the warranty deed and the insurance. So, right, even this isn't being insured by the insurance. This is being insured, but that isn't the name on the frickin' title. So these are the reasons to have it fixed. And, get this fixed first and then tell them all these other things are wrong and have them go fix them because they're supposed to protect your title. And the paperwork's wrong. But it starts with the title insurance company. It's their job. You paid them to take care of this stuff for you. And you paid, in most cases, right, if you're buying property, you had a buyer's agent. Well, you paid them to act as the buyer doing this paperwork. So it's their fault if it's wrong. And real estate has transactions have a mediation clause in them. So, well, there you go. But wait, there's more. So here's one of these uniform residential loan applications, right, that Teresa got from, we'll go back to the beginning and see where it came from, right? But this is, she asked them for the paperwork that the servicer had on her, and this is the 106 pages of paperwork they sent to her. And on her uniform residential loan application, right, that the servicer has, well, we'll look at those things later. We'll just go to let's get to the meat and potatoes first. Right? It wasn't signed by the loan originator. So you don't have a contract with anybody. There's no bilateral contract. This was supposed to be a contract in commerce, but it's not been executed. So they're not trying to enforce this as a bilateral contract because it's never been executed. We need to go tell the title insurance these people don't have a claim. And the other thing is, what is this unpaid balance on this fourth page? I hadn't seen this before, but for some reason, unpaid balance of $229. And a lot of times I see, when I'm reading people's foreclosures, that one of the things they're talking about is, attorney fees and so forth. And it's like, is this an unpaid attorney fee that didn't get paid at closing that's still outstanding? And that's what they're foreclosing on, is this fee that's never been paid. And it's an incorrect fee because there's really no reason for Capital One to be involved in this. On her transaction, she didn't do a transaction with Capital One. She did a transaction apparently with, they had some other name on here. We'll have to find it. But the other thing is, right, the borrower, they didn't use her full legal name. It says it's going to be in fee simple. And she's living in a post office box, right? Present address. What does it say? A little bit too small to read. Street, city, state, zip. P.O. Box 1221. Well, that's, that's living in a post office box. You're homeless. It's all done on purpose, right? They don't want to acknowledge that you exist. And this is the right Fannie Mae Form 103. So you just have a conventional loan, you probably have a Fannie Mae form. And the fourth page, or the third page, is where they're supposed to sign it, and there's no signature. So it didn't happen. And, you can take that to court, or at least to arbitration. This continuation sheet, it wasn't signed by her. So how do they have a continuation sheet not signed by her, but tied to her case? Anything at the bottom of the page? It's like they're, trying to slip a fast one by here again. So, okay, and let's look at this other style. Is Bob in Arizona, he actually got this, fancy looking policy. It's been signed by the president and the secretary and got the seal of the thing on it. It says, our duty to defend against legal actions. But it also says up here in the upper corner, this policy insures you, not a thing, you against actual loss, including any cost, attorney's fees, and expenses provided under this policy, resulting from the covered risk set forth below in this land. If the land is an improved residential lot on which there is located a 1 to 4 family residence, and each insured name in Schedule A is a natural person. Right? The name in Schedule A has to be a natural person because these are supposed to be residents for people. Right? That's what this insurance is for. It's not for things, it's for persons. And they replaced your person with a thing. Your insured is limited by the following. Our duty to defend against legal actions. Well, that's enough. That's what you're limited by, is you have a duty, they have a duty to defend against legal actions. So whether you're in foreclosure or you're getting property tax statements, or you're just making payments for a loan that they never signed, well, they need to defend you against that because people are putting a claim against your property. All right, someone else has rights affecting your title arising out of leases, contracts, or options. Someone else claims to have rights affecting your title arising out of forgery or impersonation. Someone else owns an interest in your title. Well, I don't know why they think they have this right. Right? That's what I got an attorney for. Go find out why they think they have this right. All I know is they can send me a fucking bill. And you have a right to defend my claim, and I'm supposed to have fee simple title. So I don't owe anybody anything if I own property. Our duty to defend against legal action. We will defend your title in any legal action only as to that part of the action which is based on covered risk. Well, then they need to tell you if it is or not, but you need to tell them what's going on. But again, the problem that you're facing is the fact that your name isn't on the damn title. Because here is Bob's Schedule A. So this is his policy, Schedule A. This is who's being covered. Right? It has the amount being covered for, the date, so forth and so on, name of insured. Right? They add him in a middle initial. And his wife in the middle initial, although she was in her maiden name with the middle initial. Right? She wasn't using his last name. Then it said Robert B., also known as Robert full name, right? Now, so like Robert B. is an AKA, or Robert full name is an AKA, full legal name is AKA for the dude with the middle initial. No, it's the other way around. And Barbara with no middle name, also known as Barbara with a middle name, last name, husband and wife. Okay, now they're husband and wife using different last names. his with a K, hers with an H. His full legal name, her full legal name, husband and wife. But prior to this, they had gotten agreement to issue policy. We agree to issue policy to you according to the terms of this commitment. So they got a commitment letter first. Before the policy, there was a commitment. When we show the policy amount in your name as the proposed insured in Schedule A, this commitment becomes effective as of the date shown in Schedule A. Well, I wonder what name they have in Schedule A on this commitment. Our obligation under the commitment is limited to the following: the provisions in Schedule A. Your name isn't on it, you're not covered. They're not obligated. Blah, 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 blah. Boilerplate, boilerplate. Got to do this, got to do that. Okay, we'll get to that later. Let's get to, well, who did you insure? And sure enough, now this one it says who's, escrow closing inquiry should be directed to your escrow officer, who is this person at the time. Title inquiry should go to your title officer, who is this person at the time. This is back in 2004, so they may not be there anymore. But what I do know is that on here, right, now this is the commitment before they get the policy. The proposed insured were full legal name of the man and full maiden name of the woman. Who'd they say it was here? The insured, right? A guy with a middle initial and a woman with no middle name. So in between the commitment and the policy, somebody changed the insured. And in both cases, it's wrong. Okay, title to the estate or interest in land upon issuance of the policy shall be vested in Bob with a middle initial. Now he's an unmarried man. And Barbara, full middle name or full maiden name, an unmarried woman, as joint tenants with right of receivership, as joint tenants with right of survivorship. That's how they're going to vest the title, in that name. Well, that doesn't sound like either of them. And it's certainly different than it was on who they vested title in on the, this is on the policy, the thing with the frickin' seal. So there's reason to go arbitrate. Say, hey, this is wrong. Wrong, 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 wrong. If they won't arbitrate, well then because of Title IX, you can take them to court and make them arbitrate. So there you go, right? This is the legal description of the property that's going to be, that you have fee simple title in. So if somebody's going to say you owe property tax, this is what it would have to be, the property tax it had to be on. And when you look at your property taxes, this isn't the legal description they use in your taxes, right? When the assessor comes, he's using a different legal description. Well, that's fraud. You don't own what he says you're paying taxes on. This is what you say you own, and you have title insurance on it. So, that's what you can show the title insurance company. Say, look, this is what I own. This is what they're taxing, but they're sending me the bill. They're claiming to be the government. Protect my title. And they have a duty to do it. They got a duty to protect your title. We just need to get the name on the frickin' title insurance. Our duty to defend against legal action. Right? Your title. You. Not a thing. And that's about that simple. Now it's a matter of doing it. So, like I said, we put one into Jackie's case in Florida to see if they're going to do that. Will they take a civil action and send it to non-binding arbitration? And in the meantime, with the couple of people I'm working on foreclosures. We're going to contact the title insurance company and get this taken care of, or try to. But whether you're in foreclosure or not, you need to go do this. You need to go find your title insurance policy and contact them and say, hey, this is wrong. My name needs to be here. Right? And if you're married, then your wife's name needs to be there. If that's, whatever you want to have on the warranty deed needs to be on the title insurance. That's how it works. And what they'll do then is they'll hire an attorney to represent you, right? And this is, you're always told when you go to court, well, you can always hire an attorney. Well, you did, because you have insurance. You hired an attorney. It's just the only attorney that the title insurance company is going to recognize is the one that they give you. So, very cool. Okay, that's all I really wanted to tell you was that, right? Arbitration rules the nation. And we'll see how it applies with federal agencies under the Act from 1996, and can you do anything with it? But if you go look at, if you Google real estate mediation, you'll see that, you go take you to the realtors' websites, and they'll talk about, mediating disputes. Well, a mediation isn't quite as strong as an arbitration, because arbitration, you can put people under oath and issue subpoenas. That's really powerful stuff. So we shouldn't be defending our real estate transaction anyways. We had a real estate agent who was acting as your buyer, acting as the buyer for you. In fact, let me show that real quick. I should show one. Hang on a second. Okay, so this real estate purchase contract goes with this loan application, right, that was not signed on page 3 by the loan originator signature. There's none there. And this is the real estate purchase contract that was done between Teresa and the real estate company, right? And she probably also did this thing called a brokerage agreement, where you're going to make the broker your agent, which is separate from this. And then this is, this is what they found for you, and now we're going to, now they're going to act as you, because they're the buyer's broker, which means they have a fiduciary duty to you. They have a fiduciary duty to Teresa to make sure that this contract is fulfilled, right? And they don't say that, but that's what they have. And this is supposed to be the property she's buying, right? It's in Tully County. And if you look at these other things, they don't have Tully County in it. So it's like they're using a defective description. D, signed. You get down here, title insurance. Seller represents the seller has fee title to the property, will convey marketable title to the buyer at closing by general warranty deed. Okay, so that's how it's supposed to be done. In title insurance at settlement, seller agrees to pay for and cause to be issued in favor of buyer through the title insurance agency that issued the commitment. Right, so there's the commitment letter. The issuing agent, the most current version of the Alta homeowner policy for title insurance. Right, so that was supposed to have been paid. It would be the home, right, the Alta owner's policy. Yeah, So there's the title insurance. You're supposed to have it. It's paid by the seller. So it needs to be in your name, right? You didn't do this. They did it. They did it wrong. It needs to be fixed in your name. It's supposed to be the buyer. Supposed to have it in favor of the buyer, but it isn't in favor of the buyer. Because up here they got the buyer as Teresa Moore. Now I say you should have your middle name in there, right? Or don't even call it your middle name, your given name. They've taken Teresa Lee and her given name and split it in half. All right, so they stole your identity. That's identity theft. Okay, and then I just, okay, so buy a general warranty deed. Well, let's see what kind of warranty deed they gave her. Right, here's the warranty deed that's supposed to have been recorded in the county. Sidney Ross, Todd Ross, grantor, hereby convey and warrants to Teresa Moore, comma, a single woman, right, a thing, the grantee for the sum of $10, yada, yada, yada. Okay, it says warranty deed on it. Isn't that good enough? Look at it. It says warranty deed. Well, in Utah, this is what it says is supposed to be in a warranty deed, right? They have a law for it. Insert the name here of the grantor and insert the place of residence insert the place of residence, right? So the grantor is supposed to have a residence. After the word grantor should say of and then someplace, but it doesn't say that. Well, that doesn't seem like it complies. Let's go on. Conveys and warrants to, hey, insert name, grantee of a place of residence. Well, to Teresa Moore, a single woman, grantee, but there's no residence. Right? So they stuck a piece of paper in, but it isn't a general warranty deed as defined by the state of Utah. And so these people, I mean, the broker is licensed by the state of Utah, and they're the ones that are licensed to do these transactions, and they did it wrong. So you're from the beginning, right? This is where the problem happens with if you're in a foreclosure. It didn't happen with them putting the case in. It happened way back at the beginning by people with license committing acts of bad faith and clericalism, basically putting administrative errors in records that are going to then be used in law. And that's what clericalism is put an error in the record and change your status. You're none the wiser, and you don't know, everybody believes, well, that's what the record says, so, you must be guilty. So that's the game they're up to, right? They just don't do what the purchase contract says. And the person that's responsible for the buyer is their broker. Oh, there was one other thing that was really handy that was in her paperwork. Jeepers. Where is that thing? Okay, these were all the documents that I believe that Teresa got from the servicer, right? Because she's in a foreclosure right now. So whoever sent in the letters sent her this information. And as I was going through it, it's like, well, this is supposed to be the name of her mortgage company, but it has a different address where they want you to send the check to than the note does. So you would be sending the checks to the wrong place. That wasn't the main thing, but what you would want to find, so another document you're going to want to find is your closing disclosure. It used to be called the HUD-1 form, I think it was. I don't know what they call it anymore, but this was something done through HUD. Because on one of these pages here, it lists all the people to contact about this crime. There it is, contact information. Right? Here's the people that were supposed to have lent you money. Well, you can subpoena them and say, did you lend me money? Right? Here's the broker that was supposed to be doing the paperwork that said that these people were going to lend you money. Here's your broker that's responsible for the faulty transaction in the first place for the buyer, and then the seller, and then the settlement agent. All right, the title insurance or the closing agent. So these would all be people that you would be subpoenaing if you had to take the case to arbitration to have them provide the records to do with the current controversy. And if they bring the controversy against you, according to Florida, any contested case, pursuant to rules adopted by the Supreme Court, may refer any contested civil action filed in the circuit or county court to non-binding arbitration. So apply for it. And then, who are you going to subpoena? Well, here's a list. It's a place to start. Is this it? Papers. So many papers. Yeah, right here. Now, if you got a loan through the Department of Agriculture, it may look different than this, because that's what Jackie said. Basically, you went to the Department of Agriculture's office and did all this paperwork. It wasn't so much done through it was a special program that the USDA had going on in her case. So you just got to file your own paperwork back and see. But there should be some kind of closing disclosure, right? And whatever these papers are going to come from who's ever foreclosing on you or acting as your settlement agent or whatever, right? That's the place to start with. Or go ask the place that you closed at who has the records. And, soon enough we'll know exactly who it is. I'll put in a video and then everyone can know. But I don't really know how you get the proper documents. You're going to have to tell me where you found them. Okay, then. Let's leave it there. Thank you very much. Have a great day. I would ask, if you could, to please pay it forward. Or you can call a charity. Send something to PayPal account, robryder@aol.com. Ask me for email me and ask me for an invoice. And I'll send you one through PayPal that you can use your credit card on for whatever amount you say you want to donate. Or you can put it in the mail. But, I'm dependent on you. So please help. Merry Christmas. Have a great day. See ya.